Madam Caroline Mboku,
Yes.
what is the HIV and AIDS Tribunal?
The HIV and AIDS Tribunal is a court, ideally, but it's quasi-judicial. By quasi-judicial means it's being headed by a board and not a judge or a magistrate. And we handle cases that come to us for people complaining of violations that have been done against the provisions of the HIV and AIDS Prevention and Control Act. We are a board of 7. I sit at the chair. Then I have board member. I have 6 other board members. Yes.
Which law establishes you?
We are established by the HAPCA Act, which is the HIV AIDS Prevention and Control Act.
Okay.
Yes.
Can I just refresh? So essentially, people would come to the tribunal if they have issues of contravention of the Prevention and Control Act.
Yes.
Okay.
Yes.
In what situations would this come about? Who essentially then would have an issue about contravention of the Act?
Okay. Ideally, the Act is set up to protect the rights of the people who are either perceived to be living with, to be infected, or to be living with HIV and AIDS. So it was brought up so as to protect their rights, their human rights, and especially their right to privacy that is provided for under Article 31 of the Constitution. And so there are situations that are, as you have mentioned, that can bring them to the court. And the first situation is where under the Act, when you look at Section 13 of HAPCA, I'll call it HAPCA.
Sure.
That is the HIV and AIDS Prevention and Control Act. So under Section 13 thereof, it provides that you cannot be tested of HIV and AIDS without your consent. So it brings about the first issue of consent. So you have to give consent. Then 14 thereof goes and says that the person who tests you must be authorized to do that. So this must be someone who has been trained by the ministry, by the Ministry of Health. And there's the pre-testing and post-testing procedures that need to have happened. And so counseling is a must, the pre-counseling and the post-counseling. And then where Prof and his colleagues come in, so for the doctors who do that, or the institutions that do that, they're not supposed to disclose your status to the public or to anyone apart from you.
To any third party?
To any third party without your authorization. So if you go there with your partner, yes, you can give authorization for the information to be disclosed to the two of you, or for you to get your information by yourself. But then again, the exceptions to the people who can give consent.
Yeah.
And this is for children. The consent is given to, it's the parents who are supposed to give the consent, or the consent to test. And then for people living with disability, that is, but especially mental disability, then this can be given to their guardian or their spouse or their children, depending on who is taking care of them. So if a hospital or an institution decides to divulge your status without your consent, then they are brought to the HIV and AIDS Tribunal, and we will handle it. Then apart from hospitals divulging, there's also instances where perhaps someone knows of your status or thinks that you are positive. Then they go ahead and tackle you head on, maybe in a WhatsApp group or whatever setting, and then they are giving people information either by saying that you are living with the virus, or you have it, or they just go ahead and say you are taking ARVs. Ideally, that is invasion of your privacy, so they're not allowed to do that. And then again, in situations like, employment, an employer is not supposed to terminate your services solely based on the fact that you are living with the HIV, you are living with HIV, or just discriminates you based on your, just goes ahead to discriminate you based on your status. Then again, even in schools, because when you go to these institutions, they're supposed to treat you with dignity. So you're not supposed to be discriminated against based on your status. So we've seen, especially the children living with HIV who go to high school, they go with they have their ARVs that they take on a daily basis. So most of them carry them during opening days. So sometimes the teachers might decide to handle the student based on the medication that they have brought, or the matrons. So they also need to be protected. So where there is ideally invasion of your privacy based on your status, then you can come to the tribunal. We've also seen cases where, assuming a lady has gone to give birth, or a lady has been taken to hospital, and then routine checks are done, then instead of the doctors divulging the status to her, they divulge to the partner. So ideally, that is not right, because it's the lady who is the patient and not the husband. So you cannot tell the husband unless you first of all tell the wife, and for her to give consent for you to tell the husband. Yeah, so those are some of the issues around HAPCA.
Many issues. Doc, on the issue of disclosure and third parties, right? I'll bring in one example: insurance. So many insurance companies would require that at least you undergo some tests. And then the insurance companies also have a list of facilities where they feel like you can go for tests. And in many cases, you find that the people who go for such tests, the results are first passed on to the insurer. And in fact, in many instances, even the person doesn't get the result.
Yeah, thank you so much. Yeah, these are the issues that we address, because ideally what should happen, you as a client of the insurance company, they should get your consent, and they should tell you that the requirement of this is that you have a HIV test. You will require to give consent, and then you'll be tested and all that. So you go to the doctor well knowing that this is a requirement, that you should have a test, and then you have a choice whether you will go with that or not. And now what has happened in many insurance companies, they have a requirement that below a certain amount of policy cover that you're taking, you don't need the HIV test. So there are people who then opt to take the cover that is below the requirement for the HIV test. But if it's going to be done, it has to be done with their consent. You have to get pre-test counseling, and you have to get post-test counseling.
Is it not a violation of the law for the insurance company or anybody to require you to disclose your status to them?
Yeah, that is a legal issue. And the chair, I'm so glad I came with the chair, because she is a lawyer, and I'm going to refer that to her.
Yes. Ideally, that one is provided for under Section 30 of the Act. And it says, it actually allows insurance. It actually says insurance are not supposed to get your HIV status if you do not want to divulge. So when you don't have to divulge, it says that the insurance companies can come up with a policy for a certain amount, and say that for the policy, say you're taking a policy of 3 million, say for the policy of 3 million, you do not have to divulge your status. So yes, the other tests will be done, but the HIV test will not be done. But if you're to take, say, a policy of 5 million, then the insurance has a right. It's allowed. That is an exception now under the Act, where it says that for a certain now the additional policy, then it is a requirement. So by the time you are going to get that policy, you will be told that your HIV status, your HIV status needs to be known. Now, they're not supposed to not give you the policy solely based on your HIV status. So if you find out that they have denied you based on your HIV status, then that is not right. But for purposes of them knowing, then it is an exception under the law.
Where do you draw the line? There's that thing of not denying you services based on your HIV status, and then there's the other small print of pre-existing conditions?
So ideally now it comes back to the insurance coming up with policies that are compliant with the law. And the law is saying, come up with the two products. Where one, you don't tell these people to do what? Where one, you don't tell these people to give their status. To contact to disclose their status. And on the other one, you can ask them to disclose their status. But do not deny them the service based on the status. So it's now upon the patient to come and say, I was denied this service based on my status.
If patients who do not even test positive for HIV and who have insurance cover and who actually discover they have a condition on the day they go to hospital, prior to that, they didn't know. And when it comes to claiming, the insurance tells them that this is a pre-existing condition. Pre-existing means I knew it before I took the cover. That is my understanding of it. If I go to hospital for one thing and I'm told I also have something else, and then the insurance cover is then now limited under the clause that this is a pre-existing condition. That's scenario one. Scenario two, if you are going to take an insurance and you're asked to go to see a medical practitioner or you go to a lab, it's their lab. They're the ones who tell you to go there. Those results are not shown to you, but they're shown to the insurer. What makes you think that once they have your blood sample, they cannot take an HIV test? And what makes you think that the insurance company may not actually have the knowledge that you have an HIV, that they know your HIV status, and they don't have to tell you that they're discriminating against you? They will find all sorts of reason to ensure that the services that are due to you are not there. You have no recourse because you are not privy to the results.
To the information.
Yes.
And that which you don't know.
Actually, and that is, so everybody, each party has a responsibility. So, for example, the insurance, the labs that the insurance use, they have a responsibility. And if they cannot say, if they do a HIV test without disclosing to you, they cannot say it was the insurance company that made us do it. So they'll be both charged. One, for the insurance company asking for this lab to do a test without you knowing. And first of all, that lab, according to the Act, the lab is responsible. You remember, the chair has said that it has to be done by a qualified person. That lab needs to know that for a HIV test to be done, you have to have pre-test counseling and post-test counseling. So if they're going to do a test without you knowing, then they have broken the law
already,
because they've not pre-test counseled you. So each of you will be liable. And so it's good that we have this opportunity, and hoping some of the people who operate labs are also listening to this. Labs as private labs and also labs within the hospitals, that you cannot do a HIV test on somebody who has not given you consent to do it, and you must pre-test counseling. Now, on the issues of a pre-existing condition, that is a bit tricky because the Act specifically says that on the basis of HIV, you should not be discriminated based on that test. But this Act is so specific for HIV tests. We know that you'll be discriminated against, for example, if you have a kidney problem or if you have some other issues that have been listed as a pre-existing condition. Now we know that we don't have an Act that covers people in those other areas, but
and
for
the other
HIV specifically we have this.
Because there'll be opportunistic infections and diseases that come as a result of your HIV status. Now they can play around those ones.
Yes.
And there is no limit to pre-existing conditions that can be brought about by HIV.
I imagine you all have very many sticky situations, and then that you'd have to then deal with and adjudicate over. Now, some of these things that we've established, so we're saying it doesn't matter what it is. When an HIV test is going to be administered, the law states that there must be pre-counseling and there must be post-counseling. It doesn't matter under the circumstance.
Pre-test counseling.
Pre-test counseling,
Post-test.
post-test counseling. It must happen.
Yeah.
It doesn't matter the situation or the circumstances for which this test is being carried out. Yes? All right. Now, blood donation happens. Come in, give blood, let's go quickly. We know also that screening takes place for this blood in order for it to be banked or in order for it to be used. When you go to donate blood, nobody counsels you. Nobody counsels you after the fact. They are going to take your blood. They will test it for HIV. We know this. How many people donate blood on a daily basis? How many of those people are counseled?
So ideally, that is wrong. They need to cancel because the Act actually says that when you're donating, be it blood or body tissues, it's presumed that you have given consent for it to be tested. So with the presumed consent, yes, you've given the presumed consent, but if at all they're going to, which they are definitely going to do, to check for the HIV virus, then the pre and post counseling should take place.
So today, anyone can actually get up and say,
I donated blood.
I donated blood. I know for a fact that they tested this blood. Assumed consent or not, I was not counseled.
Yes.
They can actually bring a case before the tribunal today from even many, many years ago. Would it hold water?
No, first of all, for the many, many years ago, this act is specific. It has a start date. So the issues that we are dealing with are after the passing of the act.
Okay,
so
even months ago, in January.
So this is a tribunal. It's a court case. Yeah. So what would happen when somebody has such a claim? There will be the claimant, and there'll be somebody responding to the claim. So you cannot prejudge. You need to know the circumstances under which this happened. Did you know that, as we've already said, that it is presumed? You know, even by the time you're donating blood, you know that it's going to be HIV tested. So you can't say that, I didn't really know. So we would hear the facts, and the ruling will be based on the evidence that will be presented before the tribunal.
When it comes to matters of tests, hospital-based tests, most times when people present themselves, say with an illness, and they draw blood, in some places you will be told what they are going to test. In some cases, they do not. In some cases, what they tell you may not be the entire story. The question I want to ask is, how conversant are our lab practitioners, medical practitioners, health practitioners aware of these laws, and how do they ensure that they are enforced?
Yeah, actually, what you're saying is really, really true. And again, I'm going to say these are the opportunities that we've been seeking to let the people know. Many of these people know and ignore them, the regulations, but others genuinely don't know. You'll be surprised in this present day and age, like what the chair has said, that you have an employer who have an employee who keeps on coming, asking for sick off. They go behind the employee, talk to a doctor. A doctor should know that this is not supposed to happen. And they talk to a doctor and they say, just do a HIV test on him. And you go for your regular visits and the doctor does a HIV test on you. Now, most probably that doctor knows that that is not right, but they're hoping they'll not be caught. But probably there are those who actually are not aware. We need to publicize. This is a message that we need to go out and tell people that there is an HIV Prevention Control Act, and doing that is against the law. Now, as to whether people will stop doing it, that's another issue. But they know that if they are caught, that is against the law.
That's a good one. Let's take a break. It's 27 minutes to 8. On this Justice Thursday, we are talking about accessing justice through tribunals, and the HIV and AIDS Tribunal is our conversation today. The chairperson of the HIV and AIDS Tribunal is Carolyn Mboku. She's in the studio alongside a member of the tribunal, Professor Walter Jaoko. As we talking about HIV and AIDS Tribunal, and we have two people from the tribunal. One of them is the chairperson, Carolyn Mboku, and a member of the tribunal, Professor Walter Jaoko. It's a 7-member tribunal, chair and 6 members. As we were taking the break, Professor, you were responding to CT's question, which was on with regards to the medical professionals and their training and their understanding of the law and their understanding of their own responsibility and how far that goes. In terms of, if in the case that you just gave, where an employer notices that, an employee is taking frequent off days, and then the employer goes behind the employees back to a medical professional and tells them, please, can you do a test, an HIV test on this one? Let me know. According to the law, the HIV and AIDS, what is the P? Prevention Control Act. You're not supposed to do that without, first of all, the consent. Don't test without consent, and don't disclose to third parties without consent. But then, like you said, there are some practitioners who may know and others who may not know. Whose responsibility is it to make sure that all of them know?
Really, it's their responsibility. First of all, as a professional, we are bound by professional ethics as well, and professional conduct. And for healthcare professionals, as CT was mentioning earlier, during their training, they are made aware that there is something called confidentiality of a patient. And this is irrespective of HIV. Even if you come to me and I've treated you for malaria, I don't go to the pub and say, CT was in my clinic today and I treated him for malaria. That is breaking confidentiality. So that is a professional ethics. Then now that is backed by the law when it comes to HIV, that you should not do that. And in that case that you've talked about, actually you've broken 3 things. One is there's been no pre-test counseling. So then there is no consent. Then there is disclosure.
Are there regulations in place to manage this entire process?
So the Act then gives directions to the Ministry of Health to give some guidelines. And there's some guidelines that have been provided, for example, counseling guidelines. And you can get this from the Ministry of Health, HIV testing, counseling guidelines. But unfortunately, there are sections where some guidelines require to be developed, and those are still lagging.
What does that mean, Chair?
There are guidelines on counseling, that is pre and post counseling, but there are no guidelines on confidentiality regarding to HIV and AIDS. It's a requirement under the Act, that is Section 20 of the Act.
Okay. There are requirements according to the Act that there should be guidelines.
Yes.
Okay. And there are no guidelines.
Specific on confidentiality.
On confidentiality. Okay.
Yes.
Who is responsible for instituting said guidelines then? Because I can imagine, because if I were the aggrieved party, I came to the tribunal and it was a confidentiality issue, and that is specific to my problem. And there is a practitioner who then told CT my business. That being my issue, and then you say there are no guidelines around which Dr. CT is supposed to have operated, then what are we doing?
So the law is there. You've heard it said, ignorance of the law is not defense. So the law is there. What the guidelines are supposed to then provide is clarity for the people who will be doing these issues of confidentiality. They are guided by their professions, okay?
Yeah.
But we are talking about now a guideline that will work across different professions, and so that is what we are seeking, and we are hoping that will be developed.
But why is it not there?
In specific areas.
I don't know.
I'm still at why it's not there.
Because we are saying that NASCOP never came up with such guidelines.
It's not NASCOP to come up with the guidelines. It is, the Act was passed in 2006. And when you read the Act, it says the Minister for Health. Right now, it's the CS, the CS for Health. There are judgments that have been passed regarding that specific section on guidelines for that are specific on confidentiality when it comes to matters HIV. Those guidelines have not been. They are provided for in the Act, but they have not been provided for as at now. But there are those that have come up with NASCOP, and as Prof has rightfully said, in their trade, there are so many other professional ethics and guidelines that are there that are cutting across their practice that is actually applicable. The only one that is not there is one that is specific for HIV and AIDS.
Does it cause a problem on the tribunal? If we're to be honest, does it cause an issue now with the absence of these guidelines if adjudication over a matter is supposed to happen and those guidelines do not exist? Would it cause an issue on a particular case? Would you be at a loss in terms of what to do because of the absence of these guidelines?
I would say no.
Would somebody not have proper access to justice because of the non-existence of these guidelines?
It will be a 50-50. It will be a 50-50 situation depending on the other parameters of the case. So it will not solely mean that there will not be access to justice.
Okay.
It's just that the justice that will be there perhaps will not be.
Can we give an example? Let's give an example.
Yes.
Okay. Again,
It helps.
Dr. CT gave information about my condition to somebody, for example, who would have been in a position to hire me. I have a contract for work. All I'm waiting for is a signature. And that's going to happen. They told me, the job is yours. I've gone and I'm just giving what things happen. I've resigned at my other position and I'm waiting for this one. Dr. CT at a cultural establishment happened to have shared this information, and the person he shared the information with was the person who is signing my letter. What? Because of that, I now lose the job. The only reason why I lost this job is because that information was shared. And we are saying that there is no guideline about confidentiality with a medical practitioner. In that case, that is the only reason why I'm at a loss. And I come before the tribunal, and then you can put your arms up and say, well, you know what?
We
There are
can
no
see everything,
guidelines. We
but
can see
then-
your problem, but we have no guidelines. So I'm sorry, but that's denial of access justice to me. Is it not?
Well, that can come, but you see, that's why this is a hearing, so that you hear both sides. If I'm a clever lawyer, I would hold, my lawyer would hold CT responsible because of training. He's a professional. Wasn't he supposed to know? Can he hide behind the fact that there are no guidelines just to do anything? No, but what was his training? He knows that he's supposed to do certain things, and so the argument will be brought by both the complainant and...
Excuse me, teacher.
sorry.
Excuse me. This tribunal, however, operates under this law that you're calling HAPCA.
Yeah,
All right?
Yeah.
HAPCA says
Yeah.
that guidelines shall be developed. Those guidelines haven't been developed. As a tribunal, what is guiding you is this piece of legislation.
Yeah. And the piece of legislation says, do not disclose to third parties. So I will still hold you accountable whether or not the guidelines are there.
Madam Chair, we
I
do not
see.
wish you to feel that this is a tribunal.
Because we don't have guidelines.
Yes. As we have guidelines. The reason why I mentioned NASCOP and their functions fall under the ministry. Okay?
Yes.
These various departments deal with specific issues. Now, HIV has been with us, for over 20 years. Okay? And there are those who've been in the process of research into HIV, care and treatment. We've gone into hoops, great lengths, where now we are at implementation science level where we not only research find, but we put that into practice. Now, that can happen without guidelines. Not possible, because the very process has to have a protocol. The protocol is a guideline, okay? When people are being cared for, there's a process that is followed to guarantee that they receive that care using every known ethical guideline that exists.
Yes.
Now, the reason why I'm going to town on this is for a very simple reason. HIV may be considered new as far as diseases go. Malaria has been there longer. Stomach aches have been there longer. Okay? However, the severity of it and what it does to the individual and the people related to them is something that had, up to date, it's there are very few diseases. Cancer can catch up, but HIV, because of the stigma attached to it, caused a lot of havoc. What can the tribunal therefore do to ensure that there's clarity? Because, as Professor Jaoko mentions, a clever lawyer would find loops. Now, a clever lawyer, just the knowledge that there is an incompleteness in this process would throw everything up in the air.
True.
For that simple thing. So, what can the tribunal do to ensure that these gaps are actually filled?
Okay. So far, there are judgments that have been passed where we are directing that the CS in charge of health should ensure that these guidelines have come up. Those judgments, ideally, nothing has happened. And so right now, where we are at, we're still new in the board, but one of our mandates is to actually go and have meetings with them and just tell them the loopholes that are there and what needs to be done. So we shall be knocking on their doors, and hopefully we shall be having the guidelines by the time by the time our 3-year term ends. Yes.
What's the process for some, and who can then come before the tribunal, and what's the process for then now lodging, I don't know if I'm using the right, lodging a complaint or then bringing a case before the tribunal?
Okay. This being a quasi-judicial process, we receive complaints through SMSs, we receive complaints through emails, as in all manner of communication is allowed. So ideally, once the information is received at the secretariat, we have a secretariat. Our offices are at Reinsurance Plaza, 10th floor, 12th floor. Reinsurance Plaza, 12th floor. So a claimant would come, explain himself or herself, and there's a claim form that is filled. The information is taken down in compliance with what HAPCA provides, and then the case is heard. For those who wish to lodge it through online, we have our website that is active. That is www.hivtribunal.go.ke. There's a tab there for lodge a complaint. You just click there, type exactly what it is, and the information will be received. The form that is there actually captures all your details, so you shall be called, and the same is reduced into writing. The other alternative for those who cannot do it online or come and access us here in Nairobi, we have satellite offices in all the former provinces. So you just go to a high court there, say that you have an issue, you want to lodge a complaint with the tribunal, and the court registry there will help you to lodge a complaint, and we shall be able to hear you.
Okay. Must it be at former provincial headquarters?
We are saying former, not the headquarters.
Can I just go to any court?
The law courts, yes.
So if you go to any law courts, you'll be able to be guided to the registry, and the registry can then take up this issue.
Yes.
Okay.
How long then? So, as that determination is made, and then you say we'll have a tribunal sitting, and thereafter, how long, or is there a time that's given, like with other tribunals, 60 days, 90 days kind of thing, within time that a case must then be determined?
Okay. The beauty about tribunal is, unlike the law courts, we are supposed to be fast and efficient, and so.
Did you say unlike the law courts was supposed to be?
Sorry. Yeah, no. Yeah,
I get your point.
Yes. You see, assuming you lodge a case in court right now, it will take you 1 year, 2 years for it to be determined. But now, because we are a tribunal, we are faster, and so we give ourselves 1 year. Within 1 year, we are supposed to have heard you and given a,
delivered.
given a determination. The only problem is sometimes these cases come, and where their lawyers, they will come and ask for adjournments, and the matter drags on. But we as the tribunal have given ourselves that target, that no case should go past the 1 year mark.
Are you permanent tribunal, or do you only meet regularly?
We meet regularly. So far, because of the number of cases that we have, we meet twice a week. That is Thursdays and Fridays. Yes.
Every Thursday and Friday.
Yes.
Today is Thursday, so
Thursday
you have
morning.
a sitting.
After this, we are rushing to the tribunal.
That is why we were asking all the time.
And maybe something else that there's some heroes, silent heroes that we don't mention a lot. We have what you call pro bono lawyers. When you come to the tribunal actually allocates you a lawyer to help you in your case, and the lawyer does it for free. So these are our great heroes that I just thought we should mention. We have a number of lawyers. When you bring in your case, we link you with these lawyers who come and support your claim legally, and it's done for free. So you shouldn't be afraid that you'll require to be paid. And then the other thing that the government has done, for all the cases that you file in court, you pay a filing fee.
Yeah.
For the HIV tribunal, you don't pay. You pay zero.
I see.
So it is attractive for people. Don't keep silent when you're discriminated against. Please come to the tribunal. The government is out to help you.
I want to finish with one question. Then, Madam Chair, there's something you mentioned about discrimination.
Yeah.
And specifically, if we look at children living with HIV and then they go to school, we want to make sure that they're not discriminated against on the basis of their HIV status.
Yes.
But also in some cases, they may require some special attention, for example, diet and all. Now, is there an obligation for a school to provide this based on a student's HIV status? Then they should be able to get some accommodation.
Unfortunately, the act is silent on that, and that is why we say the law does not cure. The law does not cure everything. So that, unfortunately, that aspect was never captured. So the law is silent on that.
So in an event where a student is in school and maybe they require special diet or they require certain specific days to go and visit their counselor or a health practitioner, what should they do?
It will come back to now the parent. Because you see, as a parent, you're responsible for your child. So it's you to now decide to what extent are you willing to tell the teachers the kind of care and attention that your child needs. Do you want to tell them she's just on special diet without divulging? I remember when we were in high school, we were just told, "Uyo simpatie maragwe," and that was it. Really, they didn't really want a medical report or something. So it comes back to the parent, whether or not the parent is willing to tell the school, or you'll just find a way of telling the school, my child needs special diet without divulging. It comes back to the parent divulging.
And if the school doesn't, now the parent and the child can lodge a complaint to the tribunal.
If it doesn't provide.
Yes.
No, you really
There's-
can't, because
there's
that's
no
not
law
discrimination.
providing for it.
The school, it is just like they're not discriminating against the child because the child is HIV positive. If the school doesn't have special diet, he doesn't have special diet. So we have to be careful to say, is that a discrimination? I think you have to prove that we are now discriminating against the child because the child is HIV positive.
Those are tricky ones.
Yes.
The real elephant in the room is how on earth do you deal with the stigma?
Yes.
Because that is what
That
brings
is the
about
biggest-
all these issues
Yes.
that get people to eventually get to the tribunal.
It's a stigma issue.
Yeah.
Thank you very much for joining us today. We know you're heading to the tribunal this morning. We'll have you again, please, if you don't mind. We'll invite you. Please come.
Thank you very much.
And say hello to all the other members of the tribunal.
We definitely do. Thank you.
Asante. Carolyn Mboku is the chairperson of the HIV and AIDS Tribunal. Professor Walter Jaoko is a member of that tribunal. We've been having a conversation about the HIV and AIDS Tribunal, the HIV and AIDS P is?
Prevention.
Yes.
Prevention and control.
Have to make sure it's not promotion. HIV and AIDS Prevention and Control Act that establishes this tribunal. Keep it here for more conversations. Good morning.
This is the Situation Room, the only way to start your day.